(22-40590) is called the State of Texas versus Elena Irvin. You, Ms. Irvin?
Yes, sir.
Present with Mr. Dusler, your attorney, and the state's attorney is going to be showing up here. Who is, I think it's going to be a no name. We don't have any state's attorneys named on these things today.
It's a new and improved system, Judge.
They're anonymous people.
I thought this was this afternoon. That's not yours.
No. All right. Does the defendant waive a formal reading of this motion to revoke probation, which was filed on October 4th of last year? Can we proceed in such? Yes, sir. Raise your right hand, ma'am. Do you solemnly swear or affirm any statement you make today during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
That's all you need. In summary, this motion states that on January 23rd, 2023, you were sentenced to 2 years in the state jail. That was suspended. You were placed on regular probation for 5 years for the state jail felony of fraudulent use or possession of identifying information. Is all of that true and correct?
Yes, sir.
Number one, violation states that you committed the offense of theft, Class B misdemeanor, on or about May 19th, 2023 in Vail County, Texas. Is that true or untrue?
I'll turn it to Alan.
Since this isn't agreed, Judge, I don't know if you need to go farther.
Number two states you committed the offense. I look at the substance.
Is there one in Dallas County?
That's the second one. Yeah.
Okay, she's currently she was convicted and is serving TDC time on that one in Dallas County.
Number two alleges you committed the offense of accident involving injury or death on or about June 20th, 2023 in Dallas County, Texas. Is that true or untrue?
Yes,
Are you pleading true to allegations 1 and 2 of this motion to revoke probation voluntarily, knowingly, intelligently, and because those allegations are true as they are alleged?
This is the moment where the hearing shifts from routine paperwork to something much more serious. A plea of true in a probation revocation case is powerful because the prosecution doesn't have to prove the violation beyond a reasonable doubt. The judge now knows she's admitting to both allegations, and that's enough to revoke probation. But here's the bigger question. If one of those violations involves a fatal crash, should a simple agreement between the parties be enough to resolve everything? Let us know what you think in the comments.
Yes, sir.
Do you understand that a knowing and voluntary plea of true to one or more violations of probation are enough to grant a motion to revoke probation by a preponderance of the evidence or greater? Your probation can be revoked and you can be sentenced to 2 years in the state jail. Knowing that, do you insist on pleading true today? I find you were pleading true voluntarily, and you understand and appreciate the consequences of pleading true.
And it's an agreement for 1 year, Judge.
What happened in this Class B theft in Vail County? What was the disposition? What about the Dallas County case?
She's serving TDC time on that.
How much?
7 years.
Is that right?
Yes, sir.
She was bench awarded, but down here for TDC. Take care of this case.
There's not going to be much longer.
Why did it take so long to get from June 20th of 2023 to here, a year and a half later?
I'm assuming
Were you in jail?
Yeah.
Up there waiting for a trial?
Yes, sir. I waited 10 months for go to work.
What happened in that case? Was somebody killed?
My son's father died.
But you were the driver.
Yes, sir.
Did you catch the atmosphere in the courtroom just now? the moment the defendant revealed that the victim was her child's father. The emotional weight of this case became impossible to ignore. For the court, this isn't just another probation violation anymore. It's a case involving a lost life, a grieving family, and a defendant who is already under court supervision. You can almost sense the judge beginning to question whether the proposed plea deal truly reflects the seriousness of what happened.
Okay, I see an agreement here that you would be revoked and sentenced to 1 year in the state jail. Is that your understanding of the agreement?
Yes, sir.
There's one. So you're placed on my probation. Okay, where I'm the supervising official over you. And in a matter of a few months, you commit a theft and someone is killed,
Yes, sir.
right?
Yes, sir.
You see anything wrong with that?
There's a lot wrong with it.
Was she an absconder too? It says federal report as of April and May of 2023 to the Travis County probation and federal report to us since February. She was an absconder when all this happened?
I was in Dallas County Jail. Oh,
When?
I've been in Dallas County Jail since people were just
Look, you weren't in the Dallas County jail when you killed somebody in a car wreck in June, were you?
jail.
Okay, you couldn't have been driving much in a jail cell, right? All right. And then committing the theft in May in Bell County, you weren't doing that while you were in the jail cell, were you?
No. Changed it.
Okay, so you were out.
Sorry.
Okay, this don't insult our intelligence. Okay.
And there it is, the turning point. Judges are not required to accept plea agreements, and Judge Boyd is making it crystal clear that he's not comfortable with this one. His concern isn't whether violations occurred. That's already been admitted. His concern is whether the punishment being proposed adequately reflects the conduct. When a judge starts talking about accountability, separate consequences, and the value of a human life, everyone in the courtroom knows the deal is in serious trouble.
I don't like it. I don't like it. Well, just say you can sigh, but we'll just have it.
I'm not sighing, Judge.
This is the kind of thing where you can't roll all of this into one. I mean, this is the kind of thing that is terrible. I mean, this doesn't normally happen. You're on a probation, and then you're going to get 1 year, which is you kill somebody, and you're stealing in just a few months after being placed on probation. Correct? Yeah. And then we're going to just roll this around as a concurrent thing. I mean, every crime here should have its own separate price that she should pay, not as a, we're going to just wrap this all and put it together as a conglomerate together. No, I intend to run this consecutively when we have a hearing, if that's what y'all want. But this is terrible. This is atrocious. I mean, to me, it just does not. The price of a human life is just not being paid here in a responsible way. You just can't roll this into one big deal. But I mean, how many bad things can you do on my watch when this happened? You weren't even reporting anymore. You were off. You were on your own. And it only took a couple of months before you were on your own, and you just made a royal mess after you had made a mess here in Jefferson County. So no, it's going to pay. It's going to have its own responsible. It's going to have its own price tag. So that's what I'm not taking. We'll just set it for a hearing. Okay.
I'll make time to secure the judgments because
I understand.
I bring
Take your
the.
time. Yeah, but this is going to be I just don't think that is a fair way.
Would you like an updated
It
post
just
sentence?
seems that human life doesn't have a price. That's with you. that is worthy, nor the rules. I mean, you made a mess here on my rules in just a couple of months.
Listen closely to the judge's reasoning. He's not just talking about one mistake. He's describing a pattern. Theft allegations, failure to report, probation violations, and a fatal crash all occurring within a relatively short period of time. From the court's perspective, probation is built on trust. Once that trust is repeatedly broken, judges often become much less willing to negotiate. Do you agree with the judge's decision to reject the plea deal, or should he have honored the agreement reached by both sides?
You're stealing, and then you're acting responsible in a motor vehicle where somebody is killed, and then you're not even reporting. So we're not going to make a package deal of selling this at 5 cents on the dollar. So I don't take it. We're going to have a hearing on it. Okay. Thank you. I'm not surprised on this one. Give me the first the trial document. Gregory Johnson, that's you? Who's your lawyer?
It's Diane.
Have you seen this?
I have not seen it, but I was.
He's tested positive for 6 drugs. Boy, wasn't that a surprise? Huh? Come on up. What is his bond, please, on Mr. Johnson? His what?
1,000.
Okay. Mr. Johnson, you have tested positive for tetrahydrocannabinol, cocaine, methamphetamine, amphetamine, and barbiturates. And of course, one of the conditions of bond is you shall not commit a crime, and it's illegal to possess either of these, any of these drugs. And you got 1, 2, 3, 4, actually 5 in your system right now, and you're not supposed to use any drugs. So your bond. Anybody want to say anything?
Yeah, sure. He wants to say something. I want to say something. I would say this originally, Your Honor. I asked the court if we could reset this case because his father just had a stroke and he's taking care of his father, so we wanted to reset for that. But I think he wanted to explain some stuff to you, Your Honor.
All thing I was doing was weed and meth. I don't know what they had in the middle. I don't know.
All you were doing were weed and meth.
Talk about a disastrous first impression. Instead of reassuring the court, the defendant has essentially admitted to using methamphetamine while trying to explain away a drug test that came back positive for multiple substances. Judges pay close attention not only to what people say, but how they say it. Right now, this defendant seems to be digging himself deeper with every sentence. When you're asking a court for mercy, credibility is often your most valuable asset.
I know it's bad.
Do you see anything bad?
Yeah, that's terrible.
Okay.
I'll go to rehab for you. You can put me on probation on 5 years just to piss test me every month. I swear to God. I swear, man, please.
You can't even use the right language, can you?
I don't
Urine test is the proper language.
Right.
You're on YouTube and everything else, and all you use is slang. It's street talk.
I don't know no slang, sir.
Yes, you do. Did you go to school?
Yes, sir.
How far did you go to school?
I went to
How far did you go to school? How far did you go to school? What grade?
8.
Sir?
8 now.
Okay, but you know urine. What you know that, and you're just using the slang words. So this is a court.
I'm sorry, but I'm really sorry.
And then of course your outfit was terrible. Now that helped.
I'm sorry. I do community service, 1,000-hour community service, and everything on.
No, you know what?
Please.
You're setting the rules.
I don't want
You're going to set the terms.
No, I'm just saying. I'm trying to plea bargain with you, man.
Yeah, I know.
You're like that.
Please bargain with me. I'm sorry about this, but this is ridiculous. You're supposed to be handling a family matter, and this is the way you do it. This is the way you honor your dad, by being high on drugs in court. Your bond is revoked. It's $60,000 is his bond. He has to have a drug patch as a condition of the bond. Sorry, but you had money to get drugs, didn't you? They're not giving them away. Yeah.
This exchange perfectly illustrates a reality many defendants underestimate. Bond is a privilege, not a guarantee. The court released him with conditions, and according to the drug test, those conditions were violated. From the judge's perspective, if someone can't follow the rules while awaiting trial, why should the court trust them with continued freedom? It's a harsh lesson, but one courts across the country confront every day. Sometimes the fastest way to lose a second chance is to waste the first one.
Your father is passed and you're just using drugs in his honor? That's not right, sir. You need to be more responsible than that. My goodness. All right, that's that one.
And there it is, a courtroom forced to confront the consequences of reckless choices. Probation was meant to be a second chance, but within months, it turned into more crime, broken trust, and tragedy. Judge Boyd's reaction wasn't just about violations, it was about accountability. Because when someone ignores every warning, eventually the court stops giving chances. In the end, this hearing became a reminder that every decision carries a price, and sooner or later, that price must be paid.
And that's the harsh reality behind hearings like this. Courts can offer second chances, treatment programs, probation, and reduce sentence, but eventually accountability catches up with every decision. One defendant lost the judge's trust through repeated violations, while another walked into court already failing the conditions meant to keep him free. In the end, these weren't just legal hearings. They were warnings about how quickly bad choices can destroy opportunities, freedom, and even lives.